Hi everyone, and welcome to our webinar, Surface Use and Accommodation Issues in Oil and Gas Development, a Refresher and Rethink. I'm Ryan from Pizzuli, Program Manager of the Institute for Energy Law, which is an institute of the Center for American and International Law. This webinar is hosted by IEL's Academic Outreach Committee, and this is the first of two sessions we have planned on traditional oil and gas academic topics. The second topic is scheduled for January 23 on produced water, other brines, and the substances in them. Who has the right? Led by Professor Keith Hall at LSU Law Center. I would now like to welcome our speaker, Professor Joseph Schremer. Professor Schremer is an associate professor of law at the University of Oklahoma College of Law and director of the Oil, Gas, Natural Resources, and Energy Center. He teaches courses in oil and gas, energy, and natural resources, as well as first-year property. He is the sole revision and update author of Kuhn's on Oil and Gas Law, a co-author of Oil and Gas Law, Cases and Materials, 11th edition, Foundation Press, and has published extensively in the law journals on topics such as correlative rights, waste, property and pore space, subsurface trespass, and split estates. He is also the vice chair of IEL's Academic Outreach Committee and helped to spearhead this webinar series. Over to you, Joe.
Thanks, Ryan. Hi, everybody. It's a pleasure to be here. I appreciate the invitation from IEL to talk about this topic, which is, like so many oil and gas topics these days, both very fundamental and suddenly evergreen, given all the changes that are happening in the energy industry. We are finding ourselves having to take a fresh look at our old understanding about use of the surface for oil and gas development and accommodation of competing surface uses. Why? Because of things like renewable energy development and increasingly carbon dioxide capture and sequestration activities occurring on the surface, some of them closely related to developing energy resources that heretofore we'd never heard of, and our old doctrines of surface use and accommodation had never had to address. And so we'll take this topic sort of like a law school lecture today. We're gonna introduce it to those who may be in the audience who do not have any idea about the basics of surface use and mineral development. And we're going to build from the very foundations of the doctrine, explaining how it works, talking about some of the older traditional surface use cases that will be familiar to our oil and gas lawyers in the audience. And we'll cover the basic topics with the end in sight, that we're going to conclude with talking about the new interesting applications of these topics, our special topics, which I'll reduce to just the three flashes with renewable energy, think wind and solar, multiple mineral development, so development of oil and gas using the surface of land in which other minerals, perhaps, don't know, maybe lithium or critical minerals is also being developed simultaneously. And then we'll talk about development of minerals, use of the surface in connection with concurrent use of the surface for CCS, which stands for carbon capture and sequestration, which is the hottest of all the hot topics these days, I believe. So starting our outline of the basic doctrine, this is the law school lecture part. We want to think about the use of the surface of land by mineral developers, and really the paradigm here is oil and gas developers, as being a question of with three basic aspects to it. The first aspect is, where do the rights to use the surface of land by mineral developers come from? Their creation is the first aspect. The second is, what's the scope of the surface use right? What kinds of activities and uses of the surface are authorized by these rights once they're created? That's the scope question that we'll look at second. And then the third issue that must be addressed, and is by far the most complicated, is when the surface owner themselves, who's subject to these surface use rights enjoyed by the mineral developer, when that person wants to use the surface for their own purposes, which they are permitted to do, and it clashes or is inconsistent with the uses uh, sought by the mineral developer, how do we regulate that clash? Who gets to pursue their use? Who must yield to the other one? And the best way to think about this that I'll address for you today, that I'll suggest as a means of analyzing these questions, is as a priority battle over use of the surface between your mineral and your surface interests. So that's our basic outline. Let's start at the top of it. The creation of surface use rights for mineral development. So let's start at the beginning here. In the beginning, with apologies to Texas lawyers out there, the beginning is not in Texas. It's not even in Pennsylvania or Ohio. The beginning of the doctrine that grants use of the surface to mineral developers stretches back into the English common law, whereas the Texas Supreme Court reminds us in this 1862 opinion of Cowan versus Hardiman, where it has been established for a very long time, the earliest days of the common law, which is honestly pretty early, that obtaining the right to minerals, and this could be the right to hard rock minerals like coal or tin, or in our case, in the Cowan versus Hardman case, minerals that are fugacious like oil and natural gas. Ownership of the right to those minerals, whether granted or reserved, carries with it the right to enter, dig, and carry them away. That is, you may enter onto the surface of the land where the minerals are located in order to exercise or enjoy your mineral rights. These rights are carried with, they're implied by law in the ownership of minerals. It's part of the mineral estate that the mineral owner has the right to use the surface. And this is by implication. And the question that you should always have in the back of your mind when encountering a right that's created by implication of law is, why does the law imply that right? Well, the reason is not entirely clear when it comes to the implied surface use rights of the mineral estate. One version of this, the version that you see quoted from Harris versus Curry, the famous Texas Supreme Court case, is that it's good public policy to imply a right to use the surface as necessary to enjoy the underlying minerals, because otherwise the underlying mineral right would be useless. So we imply the surface use rights to avoid creating a worthless property interest in the severed minerals. Okay, well that's one reason the law might imply. There's other cases here represented by the California Supreme Court's opinion in Callahan that indicate that the basis for implying this surface use right is not some public policy. It's rather inferred from the likely or presumed intent of the party who severed the rights to the minerals, either granted ownership of the or rights to the minerals to a third party, or granted ownership of the land to a third party and reserved unto themselves the rights to the minerals. That it was clearly the intent that to whomever the minerals were severed should also go all the necessary rights to enjoy the minerals, because otherwise the grant would be futile, worthless, pointless. And so we might say that the surface use rights are implied sort of as a matter of fact to fill in the gap left behind by the terms of the conveyance or reservation that actually created the mineral interest, to give effect to the intent of the parties. And there's a third idea that floats around and is associated with the eminent Professor Bruce Kramer, that we arrived at the implied surface use rights of the mineral estate by a mangling of common law implied easements, the easement that is implied by prior use of the grantor, and mangled in part with the easement by necessity, which the common law applies to tracts of land that would otherwise be landlocked, and the implied surface use easement for mineral development sort of combines elements of both, but doesn't really play by the rules of either. Regardless of where it comes from, there's no doubt in every jurisdiction that there are implied surface use rights, and only in the unusual case would you ever really need to hone in on what the basis of the implication is, although one can imagine that the question could be relevant. Similar to, shout out here to another area of oil and gas law, similar to the question of whether implied covenants in an oil and gas lease are implied on the basis of public policy, that would be implied in law, and thus are very difficult to waive, or whether they're implied in fact, which is to say they're inferred by the unexpressed intent of the parties, in which case they're much easier to waive by any kind of express provision in the granting document there, the lease. So there is a bit of a family resemblance between those concepts here. It is also possible, of course, that in any given tract of land, the mineral owner's rights to, or lessee's rights to use the surface to develop the minerals are created not by implication, but by express language, either express conveyance or an express reservation of the minerals. Now, this is not typically the case in instruments that sever a mineral estate in the first place. The organic document that for the first time in a tract of land separates ownership rights in the minerals from ownership rights in the surface. As a matter of custom and ordinary experience, we don't see explicit surface use language in those kinds of instruments, although certainly that express language could be used, and in fact, good drafting practice may well demand that when granting or reserving minerals for the first time separate from the ownership, that you express surface use rights to avoid any question about whether and to what extent they might be implied. But just as a matter of practice, you don't see them in mineral deeds very often. Where you see them always is in the grant of an oil and gas lease. And so here on the screen, you have the language of a typical granting clause of an oil and gas lease, which along with granting the rights to exploit the minerals, also identifies expressly surface use rights for a variety of individual types of uses, with the ultimate purpose being production of the minerals that had been granted. Now, even in cases where the mineral's surface use rights have been created by express language, and thus the scope of it would be controlled by the express language, even in those cases, the common law will imply additional rights that are not present. These are called secondary easements, and they're implied to the extent reasonably necessary to give effect to the express grant of the right. So if you're in the middle of drafting a laundry list of types of rights that your lessee under an oil and gas lease gets to use the surface for, and you leave something out that would be reasonably necessary, the secondary easements doctrine is there to catch you and essentially fill in the gap left behind by your express writing to give you the surface use rights that are secondary easements, regardless of whether they're included in the express grant. Okay. So even with express language, you find yourself in the world of implication. Now, courts from a very early day have quite accurately classified the surface use rights of a mineral interest, whether they're implied or they're expressed, as a form of easement. And that's because you have to classify rights in land in one of the existing types of interests that our common law system of estates and servitudes will recognize. You got to classify it as something, and the thing that it clearly is an easement, a non-possessory right, a servitude, if you will, to use another person's land. So instantly, by classifying the surface use right as an easement, we now connect into a giant body of common law governing easements. And so this body of common law regarding easements will help us to further classify the particular type of easement that implied surface use rights for mineral development is. So the first thing that we can take away from general easement law that applies equally to mineral easements is that it creates a benefit in the holder of the easement and a burden that travels with the land that is subject to the easement. And here that would be the land that is subject to the use that is the easement, and that would be the surface of the land where we overlie the minerals that have been conveyed or leased or reserved. And so the surface becomes our servient estate, and it merely reflects the fact that that is the tract of land that is burdened by the easement. And then we have to ask the next question, is this easement, the rights to use this land, is it an appurtenant easement or an easement in gross? An in gross easement is simply the right of an individual, a legal person, to use someone else's land, to use the servient estate, disconnected from any other particular tract of land. The in gross easement may be used for the convenience of its holder, versus the appurtenant easement, which inherently benefits another tract of land owned by the holder of the easement. And here it is quite clear that the implied mineral easement is an appurtenant easement because it benefits a separately owned estate in land, namely the mineral estate that was created by the grant, reservation, or lease that gave rise to the implied or express easement. And so with an appurtenant easement, in addition to a servient estate, the one that's burdened by the easement, you also have a dominant estate. That would be the tract of land or the legal estate, here our mineral estate, that is benefited by the use of the easement in the servient estate. Easements may also be classified as either common or exclusive. Common easements are essentially non-exclusive as to the owner of the servient estate. So the mere fact of a common easement doesn't mean that the servient surface estate, in our example, cannot also use the servient estate for their own purposes. They certainly can. They are not excluded from doing so. In other words, the easement is for most purposes not exclusive to the lessee, or the holder of the minerals. It's not the only party, as between the two, dominant and servient, that gets to use the servient estate. In general easement law, we presume that easements are pertinent wherever possible. We presume that easements are common and non-exclusive wherever possible. And so it takes some specific language generally to indicate an intent to create an in-gross or exclusive easement. And generally speaking, we don't have that kind of language in our mineral deeds or leases. So we assume here that we are dealing with an appurtenant easement, which means that we're dealing with a dominant and a servient estate. And so the next fundamental concept of easement law that we import into oil and gas and mineral easements is this idea of the relationship between the dominant and the servient estate. And it works basically like a right to use the surface held by the dominant estate that has a correlative duty, a corresponding duty that is owed by the servient estate not to interfere with the use rights enjoyed by the dominant estate. And so the dominant estate is entitled to use, and the servient estate is obligated not to interfere within the scope of the dominant estate's easement rights. And as long as the dominant estate's use of the land that's servient remains within the scope, then the dominant estate is merely exercising a legal right and certainly would not be liable to anyone, including the servient estate owner, for those actions. But once some act is taken by the dominant estate owner that exceeds the scope of that right, well, now they are acting on someone else's land, the servient estate, without authority, and that gives rise to potential trespass, nuisance, or sometimes called excessive user claims. Those would be claims that could be brought against the dominant estate by the servient estate for exercising without the right. Likewise, the servient estate may find itself liable to the dominant estate by interfering with the permitted right to use the surface of the dominant estate. The key here is that the duty that the servient estate owner holds, that corresponding duty, it's violated not by any interference, but merely by interference that is unreasonable. Now, this is not true on the dominant side. A dominant estate can trespass on the servient estate merely by exceeding the scope of its easement, going beyond its right. And we don't have to ask the additional question of whether it did so materially or unreasonably. A trespass would be a trespass. On the servient side, though, the interference with the rights of the dominant holder are actionable only if they are unreasonable. And so that's the basic relationship between the dominant and the servient estate. And as you can tell from that description, the relative rights and duties of these two parties turn ultimately on defining the scope of the duty that is owed and the scope of the right by the dominant holder to use the surface. We have to examine the scope of this easement. And so what do we mean when we talk about the scope? Well, there are several different aspects to the scope of an easement that may be relevant in defining exactly where the duty ends, or where the right ends and the duty ends in this dominant servient relationship. One, I want you to think about is the purpose of the easement. For what purpose is the easement created in the first place? That is essential to helping to define the scope. Second, which is very closely related, might even be the same, this is the same, a corollary of the purpose is the extent of the rights to use the easement. The third and fourth are likewise somewhat related to each other. Another aspect of the scope is which parts of the servient estate does it entitle the dominant owner to use, and what locations on the servient estate does the easement allow the servient or the dominant owner to use? So, generally speaking, the source of the creation of the easement will also define the scope of the easement. And so if you are dealing with an express easement, then the scope is a consequence of the express terms of the easement. It will tell you expressly what the purpose is, the extent of the use rights, the location of the easement. It's more difficult when you're dealing with an easement that's implied in its creation. Here we have no express language to search for to determine the scope, and so we have to examine instead what the basis for implying the easement in the first place was, and that basis gives rise to the scope of the easement. So let's imagine the implied easement for surface use that is enjoyed by a mineral estate. What's the scope of such an implied easement? Well, what's the purpose? Since it is an appurtenant easement, the purpose is necessarily for enjoyment of the dominant estate, the benefited estate. And which one is that? Here it's the mineral estate. So the very purpose of it helps to limit the scope. You can see that as we go down to the next question of the extent of the use right that the easement allows. It allows all use rights that are reasonably necessary and convenient. Reasonably necessary and convenient for what purpose? For the purpose of enjoying the dominant or mineral estate. Okay, and so here you have two limits you might think on the extent of use. You have it's got to be reasonably necessary, and it has to be convenient. So how do those two work together? They are in fact different concepts, and basically the way the courts say this work is to be within the scope of an implied easement, each use has to be reasonably necessary for enjoyment of the dominant estate. Mere uses that are merely convenient to the holder of the easement, which might be allowed in an in-gross easement kind of a setting, uses merely that are convenient are not necessarily reasonably necessary for enjoyment of the dominant estate. So a use must be reasonably necessary, and if it is, then the easement holder, the dominant estate, is permitted to pursue it in any manner that is convenient to the dominant estate. And so that's where convenience comes in. It is only It is only saying that whatever kind of use is established as within the scope of reasonable necessity to enjoy the dominant estate, if you've established that, then the way that we pursue it, the means of pursuing that particular use, can be whatever is most convenient to the dominant estate. Now, baked right in with the reasonable necessity limit on the use rights of the dominant estate is the notion that the dominant estate may only use its easement, may exercise its rights with due regard for the rights of the servient estate. Basically, due regard is saying to us, hey, remember the nature of the correlative relationship between the dominant and the servient estate? One has a right and the other owes a correlative duty. Well, the right holder cannot exercise its rights beyond the scope of those rights without infringing on the rights of the duty holder. And so the rights have to be exercised with regard to the rights of the duty holder. All that means, the only thing it means, is that the rights must be exercised within the scope of the easement, i.e., as reasonably necessary and convenient to enjoy the underlying estate. That's what courts really mean when they talk about the due regard standard. Now, what about the location and the parts of the servient estate that the dominant estate gets to use? Well, in this regard, the mineral estate, and this is true generally whether it's implied and whether it's expressed under an oil and gas lease, it's considered a blanket easement, which means that the scope of the easement is not specified as to a particular part or location on the servient tract. Instead, the dominant estate gets to use any and all parts and pieces of the servient estate, anywhere that they may be located. But that doesn't get you out of the inherent limitation that the use right is inherently limited to reasonable necessity and convenience. And so in choosing where and what parts of the servient estate to use, the dominant estate is still limited to reasonable necessity. Okay, so investigating this very basic relationship a little further, under what circumstances does the dominant estate, the mineral developer, owe the servient estate for damage that occurs to the servient estate in the course of exercising its rights to use the surface? Well, where you have a surface use that is for the proper purpose of developing the dominant estate, it is not excessive, so it's reasonably necessary and convenient. It's in a location that's reasonably necessary and convenient to development of the minerals. And every aspect of the surface use falls within that scope of reasonable necessity to benefit the dominant estate. There is no liability because there is no stepping out of the rights that the dominant estate holds to use the land. And so they're entirely within their rights. And so the Latin phrase for that would be any damage that occurs to the surface estate is not injury to the rights of the surface estate. It's not actionable. It has caused no injury. And as Blackstone would say, damnum absque in jure. You have no action for that damage. Okay. But likewise, where we have done something on the surface that exceeds any aspect of the scope, the reasonable necessity, or it was for an improper purpose, or it was in a location that was not reasonably necessary, then we have, by definition, exceeded the scope of our right. We have failed to pay due regard to the extent of the rights of the servient estate, and we are liable for any resulting damages for a trespass, nuisance, or excessive user. And so that basically means that liability falls into one of these kinds of cases. In some of these cases, it's very plain and simple, and there's very little debate. And in others of these cases, it can be really difficult for a court to determine whether there has been a violation of the scope of the easement. So you have an easy case of exceeding the scope of the easement where the mineral easement holder, the dominant estate, has used the surface for purposes not for development of minerals. The purpose of the easement, at least the implied easement, is for to ensure enjoyment of the mineral estate. And so if you, as an oil and gas lessee, use the surface of your lease to park your Winnebago because you want to take a summer vacation there, and the only purpose is to have somewhere to put your camp stove out and kick your feet up on your lawn chair and put out your little plastic pink flamingos and just vacation, well, that has nothing to do with developing minerals, and it is clearly unconnected, therefore, with the purpose of the easement. It's an easy case. You have clearly exceeded the scope of your rights and failed to pay due regard to the rights of the servient estate. That's a case of liability. Okay, well, what about this next category, the second bullet point? What if the dominant estate uses the surface estate to benefit the minerals underlying the surface estate, but also to benefit other tracts of land where it has minerals? Now, this seems like it might be an easy case, but you see I have a question mark. And that's because it's actually rather complex, and there's some authorities on different sides. And so that'll be the next couple of slides after this one. I know it's hard. It's hard to wait to talk about that. But you're gonna have to wait for one slide, and then we'll come back to it. Okay, go to the third bullet point. Liability for using the servient surface estate through means or technologies that were not invented and certainly not contemplated at the time of the easement's creation. So in an oil and gas context, this happens a lot because we have such rapid technological development occurring in upstream oil and gas. A couple of good examples here. Suppose you have the grant of an oil and gas lease. You have an express easement. This could just as easily happen pursuant to a severance in a mineral deed where the easement is purely implied. And it's at a time, 1917, let's say, where water flooding, that would be the most common form of secondary recovery operations, is unheard of, or maybe not even invented yet, or maybe it's CO2 flooding. If we were to use a more contemporary example. If later on, pursuant to that easement that was created at a time before water flooding or CO2 flooding was invented, if the dominant estate now wishes to use the surface in order to conduct a water flood or conduct a CO2 flood, is it necessarily beyond the scope of its easement? Is it trespassing simply because it's using technology that was uncontemplated at the easement's creation? Well, in general easement law, taking us out of just oil and gas easement law, in general easement law, the answer to that is typically no. But we do have some cases. Weiser Oil Company is a fun one from Kentucky in the 60s that says if the lease didn't contemplate a particular technology, then allowing surface use to employ that technology would exceed the scope of the easement. Other courts, a very recent example in Andrews versus Antero out of West Virginia, that involves a lease that's clearly would have contemplated vertical production, but now the lessee wants to use the surface for horizontal drilling. In that case, the court said that the change in technology is not, and it doesn't exceed the purpose or scope of the easement, and so it does not necessarily trespass on the servient surface estate. And that is more consistent with general principles of easement law and probably the better reasoned position, if not the majority position. Okay, of course, that use of that new technology must remain otherwise within the scope of the easement. It must still be for the purpose of mineral development. It must still be reasonably necessary and convenient, etc. Moving now to the last two bullet points on the list. Here we are in hard case territory. So if the first three are relatively easy to know whether or not the use is going to be within or outside the scope of the easement, these last two are, by their very nature, difficult to tell. So one case would be where the easement is being used for mineral development of only the underlying minerals, but the particular use for that basic purpose is not reasonably necessary to enjoyment of those underlying minerals. In other words, that there is some there's some problem with demonstrating that this is actually an action that needs to be taken in order to enjoy those minerals. And here it can be very sticky if you get a dispute between surface and mineral owners over whether a particular action is reasonably necessary. And likewise, for the last bullet point, any harm that results from an action that is arguably negligently caused, that would be, in other words, an unreasonable harm. That is also a case where it's very difficult to tell, is this activity within the scope of the easement or is it outside of the easement? And what makes both of those, which are basically the same thing, what makes those hard is that in order for us to determine whether we're inside or outside the scope, we have to determine whether the use is reasonable in some fashion. And reasonableness is inherently a vague standard. It's a normative standard. Is it the kind of thing that should have been done, that a reasonably prudent person would have done? And you cannot know with certainty whether any particular action is or is not reasonable or reasonably necessary. And so we ask a jury, and the jury decides, considering things like custom and practice in the industry, things like costs of alternatives, economics, and it's inherently fuzzy. And so that fuzziness is often a source of frustration for parties, particularly mineral developers, because you never really know for sure whether your use was reasonably necessary or unreasonable. Okay, now I promised I would come back to the question mark case. Are you liable for using your implied or express surface use rights for mineral development when you use the surface to benefit other tracts of land? Well, the easy case, again, is where you use the surface only to benefit a non-dominant tract. Whereas if you use the surface to benefit both the dominant tract and minerals underlying other tracts of land, you get into a much harder question. So the easy question is easy because you have to use the surface estate for the purpose of developing the dominant mineral estate. So if you use it for the purpose of developing some other mineral estate, you're by definition outside the scope. And so that would be where A uses its lease on one tract specifically and exclusively to gather production made on a separate lease next door, and not to gather any production from the lease where the tank battery is located. That would be an easy case of an excessive use of easement, a lack of due regard. Harder cases are where the use of the surface by the dominant mineral owner is intended to benefit both that tract and other mineral tracts. So what if you place a tank battery on lease A that gathers production from lease A, but it also gathers production from lease B? Now, the safe practice to avoid any potential liability over excessive use of your easement is to obtain a common tank battery agreement, whereby the owner of the surface estate allows expressly the right to use the surface estate for this common tank battery. But what if you don't have that agreement? Is it necessarily under the common law scope of the surface use rights? Is it necessarily excessive? And here, the general common law approach, that's just general easement law, would say yes. Use of an appurtenant easement to benefit not only the dominant tract, but other tracts as well, would very clearly exceed the scope of the easement. So not a lot of debate there. But in oil and gas world, we have cases that raise these problems, and the courts are not they're not speaking with one voice on the answer. So most courts would probably say, and this is represented by the reasonably famous case of Delhi Gas Pipeline versus Dixon, most courts would follow that general principle that the use of the easement can exclusively be to benefit the dominant estate, no others. But you have other, and here a more recent case, the Crowder case. Well, actually, Crowder follows the general rule, excuse me. So you have others that involve horizontal drilling, where the well is drilled from a surface location that's subject to an oil and gas lease, but the well is going to produce from under other tracts in addition to the tract where the surface drilling is happening. What about that? Well, Crowder said that would be excessive, applying the basic common law rule. But just this last year, in 2023, the Southern District of Ohio, in a case called EOG versus Lucky Land Management, held exactly the opposite. It said that horizontal drilling to produce from multiple tracts does not surcharge or exceed the scope of the easement on the tract where the surface location will be located. And so you have courts that go either direction there. One complication here involves when there's an express grant of an easement that expressly allows use of the surveyant estate to benefit additional tracts beyond just the dominant estate. And so courts will give effect to those kinds of clauses. A common one that you'll see in oil and gas leases would say that the land in the granting clause, it would say the land may be used for the development of minerals on this or other lands. And so that would be an express grant of the right, sort of an expansion of the scope of the appurtenant easement. Courts occasionally, like the Sixth Circuit here did in Eclipse Resources, courts will occasionally find through less than specific language that it was the intent of the parties to expand the easement in that fashion. The existence of a pooling or unitization clause in a lease was held by the Texas Supreme Court as including that as authorizing that the expansion of the use of the surveying estate for the benefit of all lands that are pooled or unitized with the mineral estate. But we do have this really interesting Crowder case from a few years ago, and Crowder involved a lease with a pooling clause in which the lessee pooled the lease with other leases to drill a horizontal well from the surface location under its lease that was going to produce not only from that lease, but all the other leases with which it had been pooled. Very common practice for horizontal development. But the court held that that would be a trespass and excessive use of the easement because it would benefit these other tracts for the reason that the oil and gas lease, even though it expressly allowed this kind of expansion of the scope of surface use rights in the pooling clause, that its express grant of that was ineffective because the lessor, the mineral estate owner, was a severed mineral owner who had taken title by a mineral deed that said nothing at all about the ability to expand the surface use easement to include development of other lands, such as have been pooled with the the dominant estate. And so since that initial severance deed was silent, it didn't give that expanded easement that the lessee, the mineral owner, when granting the oil and gas lease, couldn't expand upon those rights through granting the right in a pooling clause. A very interesting case in Crowder, taking a very strict, staunch interpretation of the general common law principle. Okay, still within the basic scope question of our easement, let's also recognize that many states have adopted legislation that modifies the scope of the easements that exist at common law or exist through the grant of an express easement under a lease or a deed. These are sometimes called Surface Damages Acts, sometimes Surface Owner Protection Acts, and their terms vary greatly. Some of them, North Dakota's is an example, are relatively simple. They simply require payment of compensation for any any kind of use of the surface that is a type enumerated by the statute. And so basically it allows use but charges compensation for the use regardless of whether that use exceeds the scope of the easement. Others require some prior notice be given before entering. Oklahoma and New Mexico are examples of these. They require that you attempt, as the dominant easement holder, you must attempt to negotiate a surface use agreement, which presumably will compensate the surveyant surface estate for surface use. Provides certain judicial procedures for situations where you fail to obtain a negotiated surface use agreement. In other words, they just modify the common law. Questions arose when these started to proliferate in the 70s and 80s about their constitutionality. A couple of different cases put that to bed. The really famous one, the Murphy case from the Eighth Circuit, basically refused to acknowledge that this modification of surface use rights, this modification of the implied easement, was really a modification of property rights, and so it didn't trigger the takings clause. It acknowledged it might be a modification of contract rights, given that it could modify the express grant of an easement under a lease, for example. but basically found that there was a rational basis for the legislation to protect the relative values of surface, such as agricultural land, and that the modifications that were made to the surface use rights were simply too minor to trigger a constitutional problem under the Contracts Clause. And so these have been upheld everywhere that they've been challenged on constitutional grounds. Hold that in mind as we talk about the new issue, the one that's been percolating in recent years. Do these surface damage acts apply only for things that occur at the actual surface, or do they apply to the use of the subsurface? For example, use of the pore space to inject salt water for disposal or perhaps for secondary recovery. Under the common law, as long as the injection is within the scope of the easement to benefit that tract of land and it's reasonably necessary, then it is authorized and no compensation is owed. Under one of these statutes, if they apply, compensation would be owed. And so one question is pore space, stuff underground, part of the land that these statutes apply to? And that's generally been held to be the case. That was held to be the case in a very recent case, Brown. It was held to be so in Mosser, each interpreting that particular state's version of this type of statute. South Dakota in the case of Brown, North Dakota in the case of Mosser. But in Brown, the court said the statute only requires compensation for certain enumerated categories of land use. And none of these enumerated categories would capture injection of salt water into pore space for waste disposal or otherwise. And so that is not subject to the statute in South Dakota. The exact opposite was the holding in Mosser, which held that pore space is part of the land. It's subject to the Surface Damages Act. And the Damages Act specifically required payment for lost use of the land through mineral development. And if you fill up pore space with salt water, the surface owner loses use of that space. And so therefore, it falls within that enumerated type of compensation. And what's interesting is in 2022, or right before that, actually, the legislature amended its statute and that was upheld in Murphy and was interpreted in Mosser to say specifically it does not apply to use of pore space. And then the state Supreme Court came back in 2022 in Northwestern Landowners and said that amendment was an unconstitutional taking of the property of the servient surface estate because they have a property right to exclude occupation of their pore space from outside fluids being injected into it, and by revoking application of the Surface Damages Act to pore space, it revoked that right to exclude and was a Loretto-style taking. And so that turned a lot of heads and is actually at the center of some follow-on litigation challenging North Dakota's unitization or pooling statute for pore space for CCS purposes. So something for court watchers to be aware of. Okay, so that's the scope, and that's really where the hard work is being done in this area of law. But let's talk about now getting into a little of the academic part of this webinar. Let's talk a little bit about this next issue, conflicts over priority of use between the servient surface estate and the dominant mineral estate. And so here's basically how we have been thinking about this for many years now. We've been thinking about it, I think, in the way that Professor Bruce Kramer's taught us to think about it. And it's been an incredibly influential way of explaining this. Professor Kramer, in an article in 1984, explained that the relationship between the two estates, dominant and servient, is governed in different jurisdictions using two different paradigms of rules. One paradigm he calls the unidimensional paradigm. And basically, he says the unidimensional paradigm is followed by courts that ask the question, when we have a clash of uses of the surface between dominant and servient, they just ask the question, did the dominant estate take an act that is reasonably necessary to development of the minerals, take an act that's within the scope of its easement? And if the answer is yes, then without considering at all the interests of the servient surface estate, those unidimensional courts applying the reasonable necessity standard, but simply give priority over clashing uses to the mineral estate. And then he classifies the opposite approach as being multidimensional, which is some states, when faced with these kinds of clashing uses between surface and mineral, they will consider the interests of both under the due regard standard. And basically they do this through application of what we've come to know as the accommodation doctrine, or the reasonable accommodation doctrine. And so those multidimensional courts, they choose instead a more balanced approach that considers both the needs and uses of the surface estate as well as the needs and uses of the mineral estate. And Professor Kramer advances an argument for the multidimensional approach that many other scholars, some of them are listed here, have gotten on board with, that's based on the idea that balancing the interests in any given clash of uses case between the surface and the minerals is necessary to avoid bad social outcomes. For example, situations that Professor Kramer was concerned about in his 1984 article, where oil and gas development is prioritized over development of valuable lignite resources or valuable potash resources. So by applying the unidimensional approach, you might accidentally sleepwalk into bad social policy by allocating our scarce natural resources in a suboptimal fashion. We've got other prominent scholars who think the doctrine is too formal to keep up with the needs of a modern society. We've got scholars who have made powerful cases that the unidimensional doctrine is unfair to surface owners because it always makes them junior in priority over surface use to the dominant surface state. K.K. Duvivier has argued that the unidimensional approach leads to more and more significant impacts to the surface, which has environmental consequences that are bad. I tend to take a different view from all the other scholars here. I tend to disagree that different jurisdictions are either in the old-fashioned unidimensional camp or the new-fashioned balancing multidimensional camp. I sort of see both of these, reasonable necessity, due regard, and the accommodation doctrine, like we're about to talk about, as all part of an integrated system that work together, but they work together in two different kinds of scenarios. One kind of scenario, one kind of fact situation is simple. It's unidimensional in the sense that one or the other estate is the one taking an action on the surface. And so in that case, it's very simple. As long as it is within the scope of that estate's rights, it is allowed. And if it is not, it is not allowed. And then this complex system operates on more complicated scenarios, what I call multidimensional scenarios. And this is where both estates, surface and mineral, each want to use the land for inconsistent purposes. So we have a clash of incompatible uses. Those are situations that have two dimensions in the sense that we have two different rights holders trying to exercise their rights in ways that mean somebody has to find an alternative. Somebody has to yield to the priority of the other. And those are more complex scenarios where this same unified system of doctrine applies somewhat differently. So in unidimensional scenarios, you're applying reasonable necessity. You're asking, are we within the scope of the easement? In multidimensional scenarios, you might have to apply the accommodation doctrine. And I think this makes perfect sense. It's very it's a good system. I think it's not perfect. It leads to some good outcomes, some bad outcomes, but on the whole, it is a baseline that you can modify to reach better social outcomes, better resource allocations, something more fair for the surface owner, something less environmentally destructive through other means like contract or legislation that refines some of these points. But I don't think you want to throw the baby out with the bathwater by just balancing everything when there's a conflict. I think applying these basic rules is actually beneficial. And so knowing how to apply the rules first requires that you know whether you're in a unidimensional or a multidimensional context. So what's a multidimensional context? It's where both parties want to use the surface or consume the surface for inconsistent reasons. So Imagine surface owner, like in the Getty Oil case, wants to run a walking or rolling irrigator. Mineral owner wants to build pump jacks that will block the walking of the irrigator. Who gets to win? Those are clashing uses. You have clashing uses where both parties, like in the Whitaker case, want to drain the same groundwater aquifer. You have clashing uses, like in the Hopped case, where the surface is needed by the mineral developer to re-enter old wells, but the surface owner wants to flood most of the surface to create a reservoir project. Two different things that can't live together. So how is it that these basic doctrines function in the multidimensional context? Well, the nice, simple general rule is this: the dominant estate will win to the extent that the dominant estate has acted within the scope of its dominant easement. So see the earlier part of the slideshow. One very common problem, becoming increasingly common in the renewables context, is this: you have to actually use or activate your dominant estate's surface use rights in order to enjoy this priority. So in cases like Lightning Oil versus Anadarko, and we'll see later Lyle versus Midway Solar, in those kinds of cases where the mineral owner hasn't done anything on the surface to use its easement, well, it gets no priority. It's not a clash. It's simply a unidimensional case where the surface owner wants to make use of the surface and is perfectly empowered to do so, so long as it doesn't unreasonably interfere with the mineral estate. Why? Because the mineral estate hasn't done anything to cause a clash at all. So generally, if you just apply the basic rule that whichever party wants to use the surface gets to, the priority will go to the mineral owner, unless this is the primary exception, this is the exception to that general rule, unless the accommodation doctrine requires otherwise. And so courts, since we've adopted the accommodation doctrine, have really started to use the accommodation doctrine as a catch-all phrase to describe this whole area of law. In fact, it is really just an exception to our general principle here. It comes to us from the due regard and reasonable necessity standards. It's just an outgrowth of that basic structure of the doctrine. It's not a new or novel doctrine that's fused on, or some kind of, in my view, some kind of an alien approach to the unidimensional common law. No, I think it is just part and parcel of those unidimensional basic principles of due regard and reasonable necessity. And here the Texas Supreme Court in two different cases has agreed with that. In Getty Oil and in Hopped, it's explained that the accommodation obligation arises out of the fact that the mineral owner owes due regard for the surface. And sometimes that due regard, that reasonable necessity, requires that it seek alternative means to pursue its use of the surface to develop the underlying minerals. So when does it? As you know, probably if you've worked in this area of law, there are basically three requirements. The mineral owner must seek alternative means. That would take a second seat, a junior seat in the priority battle to the surface estate, where the surface estate has established a use. So it's coming second, the mineral owner here. The surface owner is already using something. The mineral owner's preferred use would preclude the surface estate, that is, from continuing its use. And there are alternative means available on the servient surface estate for the dominant mineral estate to pursue that would avoid the clash. And if these three things can be established by the servient surface estate, then we would overcome our general rule and priority would go to the surface estate, and it would be the mineral estate that has to find some alternative. There are some state variations. The point I want to make here is that states that haven't expressly adopted the accommodation doctrine, Oklahoma is a wonderful example. They have the basic ingredients of it. Consider the Gulf Pipeline case, where the court requires a mineral lessee to choose an alternative location for its well, where the place it wanted to drill would be too close to an existing use of the surface by the servient surface estate and would cause real harm to the servient surface estate if not moved. And yet there's all these other places on the lease to drill that well, so alternatives exist. And if you read the Gulf Pipeline case and you don't see an incredibly close cousin to Getty Oil versus Jones, then I would be quite surprised. Okay. So let's talk for about 5 minutes here, and then we'll be all done about special topics. So these are the hot things going on right now. Let's start with renewable clashes with oil and gas development. So think solar, think wind, happening in an area where you have severed mineral interests or leases. Couple of recent cases here. Both of these involve the basic principles, unidimensional and multidimensional scenarios that we've been talking about. The first one of note is the Osage Wind case from 2011. This is the same case that's made all the headlines recently, but it's an earlier iteration of it. Here, basically, you have a severed mineral estate that sues the surface estate who is building a wind farm. And they say, you can't build that wind farm because it's going to preclude us, our mineral owner, from exercising our surface use rights to develop our minerals because we can't build all the oil and gas infrastructure we need because of your conflicting wind turbines. The court held, basically applying a unidimensional kind of theory, it said, mineral owner hasn't done anything to exercise its surface use rights, so we don't have a clash of rights here. Instead, we simply have a mineral owner who's done nothing, a surface owner who has used the land, which these are common easements. The surface owner has all the right to do, so long as it doesn't unreasonably interfere with the mineral owner. And since the mineral owner hasn't been unreasonably interfered with, we can't find that there's been any violation of the rights of the dominant estate. The exact same case, basically, in the solar context is represented by Lyle versus Midway Solar. Here we have a solar company, takes a lease from the surface, covers the entire surface except 30%, or this little rectangular box, there's a picture in the opinion, covers everything but that box with solar panels. Mineral estate says, hey, you've covered everything, all the surface where we would be able to drill our wells to enjoy our minerals, and so that unreasonably interferes with trespasses on our easement. Court says, just like in the Osage Wind case, mineral estate, you have no claim because you haven't done anything to use your surface use rights. The surface owner has used its surface use rights. It has done it in a way that hasn't unreasonably interfered with your ability to use the mineral estate. And so unless you can show a clash, we're not going to apply any kind of accommodation regime to make the surface owner move their solar panels. You have to use the dominant estate before you can have a clash and claim priority in the clash. Now, interestingly, the case analogizes to and ultimately distinguishes that Hopt case we mentioned earlier, where the mineral lessee is operating some wells on the surface, or trying to re-enter them actually, and the surface owner floods almost all of the surface, all but about 10 or 12 acres, for a reservoir. So the mineral owner sues and says, hey, you flooded the surface of my lease. Now I can't drill any wells because I can't get a rig on your reservoir. You have violated my surface use, my dominant surface use rights. The court in Hopt said, ultimately, that this is a clash. This is an accommodation doctrine kind of case. But here, the question boils down to whether that remaining 10 or 12 acres that wasn't flooded. And so you can imagine, like in the Lyle case or the Osage case, the remaining acreage that wasn't covered by solar panels or covered by wind turbines, is that remaining land enough that it allows the mineral owner reasonable enjoyment of its mineral estate? And that's what that was the basic factual question that came on appeal in Hopt, and the court basically said, you could drill horizontal wells. That's true. That's an alternative to you. But we find, this is beyond on remand in the Hopt case, we find that option is not reasonable. And that was a 1993 case. Horizontal drilling was not what it is today. And so if you wanted to follow Hopt in a Lyle versus Midway Solar context, you would want to say, okay, could the mineral developer, assuming it has tried to develop its minerals and can have access to an accommodation kind of theory, could the mineral developer sue because it cannot drill wells on this tiny little block that was left behind uncovered by solar panels. The question would become whether horizontal drilling would be a reasonable alternative available to it. If the answer is yes, which it's likelier to be in 2024 than it was in 1993, then under HOPT, you would still not have a claim for violation of your surface use rights as a mineral owner, because you have that little box where you could drill multilateral horizontal wells as a reasonable alternative to your vertical wells. And likely, I think a court would say that you have to accommodate the surface by drilling your laterals in that surface location that's not covered by wind turbines or solar panels. And so with that, alas, we did not get to CCS, but for another day. There are some papers, the last two on the bottom talk extensively about it. And so you don't need me to chirp at you any longer.